I was asked to address a number of specific issues, so I suppose what I'm going to look at is the distinction between the categories of patients under the current legislative framework, so the voluntary and involuntary category, and the particular concerns then that arise in relation to safeguards for voluntary patients. And linked to that then is the issue of whether there's perhaps a need for a third category of patient, on the basis that maybe the binary division that we have at the moment is too simplistic to deal with the complexities of people's lives. Also, maybe I'm going to look a little at some of the issues that can arise in a legal system where you have these two parallel frameworks, so because we don't have the kind of fusion approach that George has outlined. And what's really important, I suppose, when you do have these two parallel or this dual system is that at least both pieces of legislation speak to each other or communicate with each other. And finally, I'll briefly, I suppose, refer to the impact of the CRPD and the human rights of principles in relation to these issues, which obviously should be, that's the context within which we're operating. They should be informing the development of the legislation and the review of the Act. So I don't have any slides. My students told me recently my slides were very boring, so I'm not going to inflict them on you. So I'm going to go old school and just talk to you. So there's a distinction, or there's two categories that of patients within the Act. You have the voluntary and involuntary category. And the framework, I suppose, the Mental Health Act is quite limited in scope in that it only applies to the involuntary patients who are admitted through the terms of the Act for treatment to an approved centre. So the legislation doesn't apply to those who are voluntarily admitted, which are the vast majority of people receiving treatment within the Irish mental health system. The 2011 statistics from the activities of the Irish psychiatric units and hospitals suggest that 9.5% of all admissions were involuntary. So you have the vast majority of people within the system are voluntary patients, yet the statutory provisions don't apply, or the safeguards don't apply. And so those voluntary patients are not entitled to, for example, the automatic periodic review of the ongoing need to receive treatment. And they're not automatically appointed with a legal representative. There aren't safeguards, second opinion safeguards in relation to treatment. The codes of practice that are developed by the Mental Health Commission do apply in relation to voluntary patients, but the statutory safeguards are not in operation. So you have these two categories. You have voluntary and involuntary, and then the safeguards depend on that legal status. So you could have two patients in the same ward with the same diagnosis, one voluntary, another involuntary, and the involuntary patient will be entitled to the safeguards and the voluntary patient won't. And that system may perhaps be defensible if your understanding of a voluntary patient is someone who has decision-making ability, who has freely chosen to become a voluntary patient, who can freely choose to leave, they can choose to refuse treatment, for example. Now, I'm leaving aside here a whole other issue of de facto detention and people who feel that they cannot leave because maybe there's the threat of recategorization hanging over them. But without engaging with that, if that was your understanding of voluntary patient, then perhaps having voluntary patients and involuntary patients with very different safeguards perhaps makes sense. The 2001 Act, though, doesn't contain a positive definition of a voluntary patient. So the understanding of a voluntary patient within the statutory framework, which has been set out in Section 2 of the Act and approved by the Supreme Court in the EH case, applied by the High Court in the PL decision, is a person who's receiving care and treatment in an approved centre who is not the subject of an admission or a renewal order. So that's a very circular and a counterintuitive understanding, really, in that anyone who is not an involuntary patient is a voluntary patient. There's no requirement that that person have actually volunteered to enter the hospital, that they have consented to admission. And so their decision-making ability isn't considered in determining their status, whether they're a voluntary or an involuntary patient. In the PL case, you had someone who was actively attempting to leave the hospital repeatedly, who was categorised as a voluntary patient, and the High Court felt that that was reasonable if he was a voluntary patient, which doesn't seem to make sense just in terms of the ordinary understanding of the word, what we would understand as voluntary. We wouldn't expect if you repeatedly try and leave that you can still be acceptably understood as a voluntary patient. Obviously, within this context then of that particular definition of voluntary patient being in the Act, a particularly vulnerable group that exists within the current framework are patients who lack decision-making ability but are compliant. So they're not objecting, they're not trying to leave, they're complying but they lack decision-making ability. And so they're categorised as voluntary at the moment. So those are patients that perhaps would be known as coming within the Bournewood gap, and I know Bill, you're probably going to talk a little more about that, yeah. So those patients, they may be at risk of deprivation of liberty, they may be at risk of having other rights violated, but there's no independent system in place at the moment to safeguard their rights. And I mean, the current position in Ireland in relation to voluntary patients has been criticised by various international human rights monitoring bodies, so the European Committee for the Prevention of Torture, the UN Committee Against Torture in the context of the periodic review of Ireland under the Convention, have noted that voluntary patients in Irish centres are in fact detained. So people are on locked wards, or they're subject to treatment or care regimes which involve a significant deprivation of liberty. If they leave, they're returned, and they're not voluntary as we perhaps would expect that word to mean. So there's a need for a positive definition of voluntary to be included in any revision of the Mental Health Act 2001, and that was recognised by the steering group in their interim report, and they recommended a definition of voluntary. And the definition proposed was someone who consents on his own behalf or with the support of others to admission to an approved centre for the purpose of care and treatment for mental illness. So in many ways that's a positive definition, and it recognises the importance of consent in any voluntary admission. It includes the possibility of supported decision making, so those are all positive aspects of it. The steering group then stated that the category of voluntary patient could include the following: a patient with the necessary capacity to make admission and treatment decisions and who has consented to admission and treatment; a patient with fluctuating capacity who requires support to make decisions in relation to admission and treatment; and a patient who lacks capacity and consent for admission and treatment has been provided by a personal guardian. So I suppose there would be a concern in relation to the last category of patient immediately. If someone's admitted on foot of the consent of a guardian or a third party, then he or she isn't truly voluntary. They wouldn't marry up even with the first part of the definition that was put forward by the steering group, which is someone who consents on his own behalf or with the support of others. You also have a question as to whether a guardianship or a substituted decision model would be human rights compliance and CRPD compliant in light of Article 12. So that would be one concern, that category of persons would come under voluntary patients. In relation to those patients then who have fluctuating capacity, so who require support to make a decision, again, there would be a concern in categorising that group as voluntary, because those patients may switch from being voluntary to involuntary depending on whether they have the ability to make a decision about their admission or continued admission at any given time. So, if the capacity isn't necessarily static, then having a very rigid kind of binary division of categories maybe isn't appropriate. Then also you have that compliant patients who have decision-making difficulties, the Bournewood gap patients. Again, there's a question as to whether they should come under the category of voluntary. So they may not be objecting, but again, the positive consent required to be truly voluntary isn't present there, and so does it make sense to categorise them as voluntary patients. So Amnesty has a very strong position on this, and Anne-Marie referred to it earlier, that the definition of voluntary should only include those persons who have expressed their will and preference to receive care and treatment in an approved centre, and that would be informed by the human rights approach to mental health law in keeping with the principles of Article 12. The question then arises if you think, okay, well, as I said, we have 9.5% of patients are involuntary admitted. The rest at the moment are voluntary. If you have a concern about some of the groups who would go into the voluntary category as it currently stands, being in that box, because we don't think it makes sense in terms of what actually amounts to a voluntary admission, well then, what happens? So do you move everyone from the voluntary to the involuntary category? Is that the most appropriate way to deal with the issue? Or do you think that perhaps what you need is a third category of persons that more accurately reflects the complexity, I suppose, of the situation? The most straightforward option, I suppose, is to move people from voluntary to involuntary, in that, you know, it's straightforward. You recategorize people, and then the statutory safeguards that currently exist in the Mental Health Act are at least available, which is second opinions for treatment without consent, automatic periodic review of admission and detention, the requirement that you would have a counsellor, a legal representative appointed for you. So it's straightforward. It's probably too simplistic though. Again, people with fluctuating decision-making ability don't neatly fit into one category or the other. They can change. Categorizing them as involuntary isn't necessarily accurate either, same as categorizing as voluntary. Equally, those patients that come within the Bournemouth category, or that were in a position similar to Ms. EH in the EH decision that was before the Supreme Court, they can't be voluntary under a positive definition of the term, but nor necessarily should they be involuntary if they're not objecting. There are other reasons as well, you know, not to categorise maybe significant groups of people, or you know, more people into the involuntary category. One of the reasons would be there would be significant resource implications, which perhaps might not go well with government in this area of austerity and cuts. The optics of reclassifying people, you know, significant numbers of people in approved centres or care homes aren't good. It would seem odd, I think, to many observers, and to be at odds with a human rights approach to mental health law and mental capacity law, if you suddenly recategorise huge numbers of people into the involuntary category. But I suppose maybe one of the most compelling or convincing arguments for not doing that is because of the stigma that still attaches to the label of involuntary. And I think where I spoke about this brilliantly and really expressively already, you know, people don't want to be in the category of involuntary, and so, and it can have a you know, a negative impact on perhaps people's prospects, or the impact on care and treatment decisions made in relation to them if they are labelled as involuntary. So there are a number of concerns as to reasons why you may not want to move more people into the current involuntary category. So it would seem that binary, that division, isn't sufficiently nuanced, as I said, to deal with the complexities of people's lives, and so that maybe we should think about this third category. If you were to have a third category, it would be very important that sufficient supports and safeguards would be made available. Amnesty again has suggested that, you know, before admission you would have sufficient supported decision-making options exhausted, that, you know, peer advocates would be made available, information would be made available, advance directives could be used. It would be necessary to establish that all attempts had been made to, you know, recognise the will and preference of the person before he or she would be admitted. Once admitted, then it would be very important that sufficient safeguards would be in place to ensure that the person wasn't deprived of liberty, which may require an independent periodic monitoring of the need for admission or treatment, perhaps safeguards in relation to consent. But again, I suspect that Phil might be talking a little bit about some of the complexities involved in that. If there is a third category, this links in, I suppose, to the next issue I was asked to talk about, which is, would the relevant safeguards be addressed under capacity legislation or under the Mental Health Act as reviewed? And so we need to think about that interplay between mental health legislation and capacity legislation. So while the fusion of mental health law and legal capacity law might be ideal, and George has highlighted how it would reduce stigma and discrimination, realistically I suppose it's unlikely to occur in Ireland in the near future. The emphasis at the moment is being placed on developing capacity legislation that will operate in parallel to the Mental Health Act as reviewed. And so if we're going to have that dual model, that capacity legislation and mental health legislation, then as I said, it's important that those would speak to each other, and that you don't have vulnerable people, I suppose, falling between two stools or falling between the two pieces of legislation. One of the key issues that arises in that kind of dual system is if, for example, you have a person who lacks decision-making ability, who has a mental disorder, and is being treated in an approved centre, then should the safeguards, for example, against unlawful deprivation of liberty, arise under the Mental Health Act or the Capacity Act, can all the necessary safeguards for someone be contained in capacity legislation? Would it be sufficient to deal with the complexities of the situation, or would there be a need to have additional safeguards in the Mental Health Act in those circumstances? I don't necessarily have the answer to that, but I suppose it's worth keeping in mind the different ethos underpinning both sets of legislation, because that might impact on the effectiveness of the safeguards that are available. Capacity legislation is generally enabling in its intent, so it's to support people in making decisions. And so the safeguards are not necessarily always designed for or directed towards situations where there may be very significant interference with individual rights. And that's understandable, that's not the core purpose of the legislation. Mental health law, on the other hand, I suppose at its core it's based on an interference with individual rights, albeit up until now very much it has been justified on the basis that it's for a legitimate purpose. And so in theory, I suppose that the safeguards might be more robust because of that. I suppose because there's that inherent awareness of the interference with individual rights. But that said, it would seem that it should be possible to draft capacity legislation that would be sufficient to safeguard the rights of particular groups. But I suppose that awareness would need to be brought to the drafting of it, and how you would make sure that the safeguards were sufficiently robust. Another issue for consideration in a dual model is the criteria that you use to decide which legislative framework a person is directed towards. So would you look primarily at decision-making ability, or deprivation of liberty, or an objection on the part of the individual? So what would the trigger mechanism be? In many cases, if there's no deprivation of liberty involved, then the Mental Health Act is unlikely to be appropriate. And so the capacity framework may be more appropriate. In the England and Wales, as you understand, if the person is objecting, then the mental health framework should be used. But I suppose there's a question then as to how you measure objection, and what is a sufficient objection to divert you into one pathway or the other. And the definition you use of objection will impact on the numbers who are channeled into one framework or the other. So it is important that you would have very clear criteria to decide how someone would be allocated to one framework or another. And I think, George, you highlighted that briefly earlier as well, that there's a difficulty in operating that in a dual system. From a practical perspective, because we don't have the mental capacity legislation, we don't have the mental capacity bill, the review of the Mental Health Act can't assume that matters will be addressed in the capacity legislation in case that doesn't materialise. So it's a less than ideal circumstance to be reviewing the Mental Health Act knowing that there will be capacity legislation, knowing that we'll have a dual system, but not knowing what's in the capacity legislation while you're trying to review the Mental Health Act. So the most cautious approach, I would think, and the one that would best protect service users, is for the review of the Mental Health Act to address any concerns that arise within the framework of the Mental Health Act, to ensure that sufficient safeguards are incorporated into mental health law. It's too risky. I know we said we can't necessarily determine risk, but if to leave things to the capacity legislation and think, well, we won't worry about it here because it will be dealt with there, or that's more suitable to be dealt with in capacity legislation. If you don't know what's going to happen, then we need to recognise that there are difficulties here and there are human rights concerns, and so we need to address that in the context of the review of the Mental Health Act. Again, you know, as I said at the outset, human rights principles really must underpin the mental health law, the review of the Mental Health Act, and also the capacity legislation. Emphasis being on non-discrimination, on the will and preference of the individual. And I suppose Article 14 is the article that's maybe particularly relevant in the context of mental health, or the one that jumps out immediately. In relation to this emerging view that Article 14 requires repeal of laws which provide for detention on the ground, amongst other things, of that someone has a mental health problem. And I suppose the expert group needs to consider whether the continuance of a separate system of mental health law is justifiable in light of the Convention on the Rights of Persons with Disabilities. I'm not sure that that's going to happen in the very near future, but I think, you know, in reviewing the Act, it's important to be aware of that, and that should feed into the discussion. And, you know, if we have parallel systems for a while, it should be something that's being considered and being factored into any reforms of the law. And again, in relation to the capacity legislation, which obviously will have to interact with the Mental Health Act, that, you know, and it's been discussed previously, the idea of substituted decision making, of guardianship model, that's really something that doesn't seem to gel or to fit with Article 12 of the CRPD. And it's significant, I suppose, that we try and ensure to the greatest extent possible that the law is human rights compliant. You know, principles are out there, principles are available to inform the drafting of the bill, and that should really be taken into consideration. I think that had pretty much covered what I wanted to cover. But if anyone has any questions, as I said, we have time for question and answer. So thank you very much for your time.